I want to say welcome, ladies and gentlemen, to the Tony Hollis Live Late Breaking News. I'm coming to you all. Um, Let me try to get myself back on screen. I'm coming to you all to bring you late night breaking news, okay? Don't know if many of you know, but there has been a federal lawsuit filed against Blytheviile School Board of Directors, okay? I have the lawsuit in my hand. It's a federal lawsuit, of course. This lawsuit was filed by, let me go up here. Lawsuit was filed by two employees, okay? They are former employees of the Blytheviile School District. And we're going to talk about that just real quickly, and then I'll be out of your way, okay? So just give me a minute to get things lined up for you. And we're going to talk about that. Let me bring up the lawsuit and put it on the screen right now for you, okay? Let me go ahead and transfer that now. Make sure I get everything out of the way here. Okay, let me take my banner off. Like I still got my banner up there. All right, take my banner down. Now, this is the lawsuit that was filed in the federal court. Actually, this lawsuit was brought up on the statute of retaliation. Okay, that's basically what this lawsuit was filed. The reason it was filed was retaliation against two former Blytheviile employees. Okay, let me put their names up there. I thought I had their names up there. If I can go back, and we're going to put their names up there. Okay. All right. But this is their names right here. The Blytheviile former. I want to try to move that. Get that out of the way so you all can see it a little better. Okay, there you go. This lawsuit was filed by the former Blytheviile School employees, Assistant Superintendent Malcolm Jones, and Athletic Director Leon Harris. They filed this federal lawsuit against the Blytheviile School Board of Directors, okay? I'm going to read you a little bit of the lawsuit that I have in my hand here. And afterwards, I'm going to say a little few remarks. And if no one have anything to say, then I'm going to go ahead and shut it down, okay? But anyway, this lawsuit, let me blow this up for you where you can see exactly what I'm talking about, okay? All right. Let me transfer it now. Okay, take off my banner. Now, if we will thumb through, let me go up here. We're going to thumb through this lawsuit, as you can see. Going to read you the definition. It's retaliation right here, okay? That's what this lawsuit was brought up under. Retaliation. This is the statute, okay? 16-123-108. Okay? This statute covers retaliation. Retaliation. A person shall not discriminate against any individual because the individual in good faith has opposed any act or praxis made unlawful by this subchapter, or because the individual in good faith made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under this subchapter. Of course, you got some other things down on the bottom. Got interference, cohesion, or intimidation. It is unlawful to coerce, intimidate, threaten, or interfere with any individual in the exercise of enjoyment of or on account of his or her having exercised or enjoyed or on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of any right granted or protected by this subchapter. Okay, Of course, you get the remedies and everything, if you want to read more about that. But look up that statute. Okay, that statute again is 16.123 108. That covers retaliation, okay? Retaliation, interference, and also it gives you remedies. That's what this lawsuit is about actually, and that's what we're gonna get into. All right. Now, this lawsuit, as you can see right here, it was filed in the United States District Court, Eastern District of Arkansas, Central Division. Leon Harris Jr. and Dr. Malcolm Jones versus Blytheviile School District Board of Education Desmond Hammett individually and in his official capacity as Blytheviile School District Board of Education President. Okay, and this basically the complaint. I'm not going to read all of it. Just going to give you enough to understand why Mr. Harris and Mr. Jones brought this lawsuit. Okay. All right. Let me thumb through it. As like I say, we don't want to read all of this here. Just want to give you important parts of why this lawsuit was filed. So we're going to go to paragraph 7 right quick, okay? We're going to go to paragraph 7. Again, but I think I need to read you this, though. It say, all action was taken under the color of law. I'm at number 4. It say, these claims are brought pursuant to both the constitutional and employment provision of the Arkansas Civil Rights Acts, ACA 16-123-108, constitutional violations under this case is assigned to Judge Miller. That's the judge that's going to hear the case. Under ACA 16-23-105, it just goes on to talk about the federal violations that might have been committed. Again, this statute was brought on the color of law. Also, Title 7 of the United States Civil Rights Acts of 1963. Okay. Now we're going to get into paragraph 7. Defendant, let me read from my paper. Defendant, Blytheviile School District Board of Education was plaintiff employer. Defendant, Blytheviile School District Board of Education President Desmond Hammett was in a position to influence plaintiff employment due to their positions as Blytheviile School District Board of Education President. Okay. Defendant Desmond Hammett took action with the purpose of adversely affecting plaintiff employment due to plaintiff opposition to actions taken by defendant Desmond Hammett, which constitute a waste of public funds. Defendants are sued for retaliation under the ACRA. Let me thumb that down. ACRA and for the violations of the ACA 16-123-108 as well as the Arkansas Whistleblowing Protection Act. All actions were taken under color of law. Okay, and we're gonna skip over to page 3. Okay, I'm gonna skip over to page 3, and we're gonna start at paragraph 11. All right. It say, by engaging in the conduct attested to above, defendant Desmond Hammett effectively wasted the public funds constituting plaintiff Leon Harris Jr. salary, renting Blytheviile School District athletic facilities and gymnasium to the public takes place pursuant to policy outlining the procedures for renting the aforementioned facility. Management and oversight of these facilities was part of plaintiff Leon Harris Jr. job. Defendant Desmond Hammett Raise that up a little bit. We're on 13, y'all. Okay, we're on 13. Defendant Desmond Hammett demanded that certain individuals be granted special privileges regarding the use of the aforementioned facilities, such as the use of such facilities free of charge in violation of established district policy and procedure. This also deprived the district of the revenue that would have otherwise been generated had defendant Desmond Hammett followed the district policy and procedures. Okay. Where am I? On 14. Okay. Effectively, defendant Desmond Hammett has, by his action, deprived the district of lawful public funds. Paragraph 14. Plaintiff Leon Harris Jr. would contest these actions by defendant Desmond Hammett, much to the latter displeasure. Indeed, in one instance, defendant Desmond Hammett cussed out plaintiff Leon Harris Jr. for not allowing one of those persons specifically favored by defendant Desmond Hammett to use district facility for free. Okay. Verse paragraph 15. It say, this also constitute a waste of public funds because even though the district is not taking in revenue from these free rental arrangements by defendant Desmond Hammett, the district must nonetheless expend funds to clean the facility for their free use and pay district personnel to be there and monitor their free use. Verse 16, we're thumbing up. I'm going to try to get through this quick as I can. Paragraph 16, what I mean. I said verse, didn't I? Paragraph 16. The individual who received free use of these facilities, thanks to defendant Desmond Hammett, made money by charging teams a fee to play at the facilities and charge for admission and concession. Yet the district made no money. Defendant Desmond Hammett effectively arranged a public subsidy of certain citizens for profit business venture. Paragraph 17. Defendant Desmond Hammett exposed the district to potential liability in the event of an injury to individuals at these events. Paragraph 18. By engaging in the aforementioned activities, defendant Desmond Hammett has favored certain citizens over others in a way that resulted in monetary gains for those favored citizens and could potentially influence them to vote in favor of defendant Desmond Hammett. Paragraph 19, take it up a little bit. It's a defendant Desmond Hammett would raise the issue of renting district athletic facilities directly to defendant Blytheviile School District Board of Education in violation of established district policy and procedure. This circumvented and undermined plaintiff Leon Harris Jr. authority as athletic director, compromising the integrity of the process and also undermined plaintiff Leon Harris Jr. ability to execute his job responsibilities effectively. Okay. I'm trying to see, or do I need to read this? It's a verse 22. We're going to script down there and cross over. I keep saying verse. Paragraph 22. Paragraph 22. Plaintiff Leon Harris Jr. became aware of rumors spread by defendant Desmond Hammett that his tenure as head boys basketball coach was coming to an end. Verse 23. Paragraph 23. Get it together, Tony. Think I'm in church, huh? Paragraph 23. Defendant Desmond Hammett attempted to get defendant Blytheviile School District Board of Education to post a job opening for plaintiff Leon Harris Jr. position. Head boys basketball coach, while plaintiff Leon Harris Jr. still held the position. This amounts to defendant Blytheviile School District Board of Education directly intervening in district personnel matters and cause the district to be inefficient. These things were done. Let me top down. Paragraph 24. These things were done by defendant Desmond Hammond in retaliation against plaintiff Leon Harris Jr. for his pushing back against his violation of district policy and procedures and waste of public funds. 25. Subsequently, plaintiff Leon Harris Jr. contract with defendant Blytheviile School District Board of Education was not renewed and his employment was terminated. Paragraph 26. It's a plaintiff Leon Harris Jr. termination was in retaliation against him for his pushing back against defendant Desmond Hammond for violations of district policy and procedures and waste of public funds. Verse 28, let's drop down. It's a plaintiff, Malcolm Jones is where we at now. Okay, paragraph 28. Plaintiff Malcolm Jones was an assistant superintendent for defendant Blytheviile School District Board of Education at all times relevant to the present case. Plaintiff Malcolm Jones was aware of defendant violations to district policy and procedures and waste of public funds enumerated above. Okay, where we at now? Go over to 31, 30 and 31. Paragraph. Plaintiff Malcolm Jones attempted to raise these issues to appropriate authorities, including defendant Blytheviile School District Board of Education, to no avail. Plaintiff Malcolm Jones attempted to raise these issues with the school board, and when he did so, defendant Desmond Hammond said to plaintiff, "I got your ass." Paragraph 32. Paragraph 32. Following the activities of plaintiff Malcolm Jones to raise these issues to defendant Blytheviile School District Board of Education, his contract was not renewed and his employment was terminated. Paragraph 33. Plaintiff Malcolm Jones' termination was in retaliation against him for his pushing back against defendant Desmond Hammond for violations of district policy and procedures and waste of public funds. Paragraph 34. It's a defendant plaintiff school district board of education retaliated against plaintiff Malcolm Jones by not renewing his contract with the district and terminating his employment. Arkansas law entitled plaintiff to a grievance hearing to contest the non-renewal of their respective contracts and termination of their employment before defendant Blytheviile School District Board of Education. Plaintiffs were afforded no such hearing. Okay? Then we start getting into the counts. Okay? They wasn't afforded no such hearing. Accordingly, defendants have deprived plaintiff of their rights to due process in violation of his rights under the United States and Arkansas Constitution. There were 3 counts. Count 1, as you can see on the board, on the screen that is, count 1 is simply where the plaintiff realleged the foregoing paragraphs as though fully stated herein. Okay? Count 1. Count 1. Let me read it. Defendant has retaliated against plaintiff for plaintiff pushing back against defendant Desmond Hammond for his violations of district policy and procedure and waste of public funds, as well as exercising free speech rights, petition rights, and the right of remonstration. All defendant are sued under the ACRA Title 7, Section 16 123 108, the Arkansas statute, as well as under 42 USC 1983 for violation of plaintiff rights to re what's that remonstrate under the Arkansas, y'all excuse me, a constitution. As a direct result, plaintiff, let me raise this up. We're on paragraph 40. As a direct result of defendant conduct, plaintiff have lost wages, endured physical, emotional, and mental suffering, lost fringe benefits, and had negative references entitling them to compensatory damages. 41. Defendant have acted in intentional, malicious, and willful violation of the law. Merrigan plaintiff, punitive damages. Count two. Okay, and to count two. Plaintiff realleged the foregoing paragraph as though fully stated herein. By virtue of the facts alleged herein, plaintiff were terminated in violation of the Arkansas Whistleblowing Protection Act and the ACRA for opposing the waste of public funds by defendant Desmond Hammond. Plaintiff protests against the waste of public funds by defendant Desmond Hammond were protected under the Arkansas Whistleblowing Act. Okay, let me take this up a little bit. "45. Plaintiff had a good faith belief that defendant Desmond Hammond has wasted public funds. 46. Accordingly, defendant action in terminating plaintiff were in violation of the Arkansas Whistleblowing Protection Act because plaintiff reported their concerns to an appropriate authority and were terminated by defendant for doing so. 47. It says, as directed and proximate cause of defendant acts and omission alleged herein, plaintiff have suffered severe mental and emotional distress, lost wages, lost earning capacity, and incurred other damages in an amount to be proven at trial. Last count is count 3. Right there starting at 48. Plaintiff realleged the foregoing paragraph as though fully stated herein by not affording plaintiff the grievance hearing to which Arkansas law entitles them. Defendant have deprived plaintiff of their rights to due process in violation of the United States and Arkansas Constitution. As a direct and proximate cause of defendant conduct, plaintiff have lost wages, endured physical, emotional, and mental suffering, lost fringe benefit, and had negative references entitling them to compensatory damages. 51. It's a defendant have acted in intentional, malicious, and willful violation of the law, meriting punitive damages. Jury trial demanded. 52. Wherefore, plaintiff Leon Harris Jr. and Malcolm Jones pray for punitive damages and compensatory damages, payment for his mental, emotional, and physical suffering, for back pay, for an injunction requiring defendant to take appropriate steps to address the hostile work environment, cease retaliation, cleansing of his file, destination as rehireable, a positive reference, an apology, posting of the verdict, training for management and elected officials, for reasonable attorney fees, for costs, trial by jury, and for all other relief the court deemed just and proper. That's the end of the court lawsuit that I read to you all. That's it. The attorney is Sutter and Gillum, attorney at law. They out of Little Rock, and look like they also have a few others. But anyway, it's the law firm Sutter and Gillum, who is the attorneys for the plaintiff. Okay, so hopefully, hopefully, let me bring myself back on right quick. So hopefully, you all got an understanding as to what went on regarding the lawsuit. And I will say that this lawsuit is going to cost the taxpayers. So many other things is going to occur as a result of this lawsuit being filed. If for any reason that we lose this lawsuit, if for any reason we lose this lawsuit, it's going to cost the taxpayers, you and I. Okay, so let's talk about some of the things that could occur as a result of this lawsuit, being filed. So let's talk about some things that can, put us in the red in terms of having to pay these lawsuits. Okay. Again, as I indicated, for those of you who just tuning in, Blytheviile former employees filed a federal lawsuit. Assistant Superintendent Malcolm Jones and Athletic Director Leon Harris filed a lawsuit in the federal court. Okay, for those of you who are just tuning in, that's what we're talking about. A lawsuit has been filed. All right, up under what we call retaliation. That's the statute that governs retaliation, 16-123, 108. Okay, let me push that over. I don't know if you all saw this hearing, but we initially was talking about how the lawsuit was filed by Mr. Malcolm Jones, who served as superintendent, and the athletic director also was fired, Mr. Leon Harris. Okay, those two gentlemen. Of course, they filing upon the statute of retaliation. That's the statute there. Okay. Now, what are some things that could happen as a result of the school district being found liable for the wrongful termination of these two employees? So what could happen? Okay. Well, I tell you. Number one, we could have the school district millage tax increase, okay? Because we got to find a way to pay these lawsuits if we lose, okay? So it could lead to your taxes and my taxes being raised, okay? The millage tax increase, all right? What is something else that could happen? Okay, we got to talk about the budget, all right? Reallocation of the budget. Sometime, what does that mean? If we don't have the money in the budget because of this lawsuit, we have to go back and we have to go ahead and amend the budget. That could lead to what? Layoffs, okay? Layoff of staff and cutting of services, okay? What's another thing that could happen? Attorney legal fees. Guess who pay that? The taxpayers. We will be the one who foots that bill, okay? What is something else could happen? Okay, insurance premium increase. Our insurance, which we have a blanket cover over our property, what have you. And I imagine, that'll have something to do with the bond rating being affected in terms of, whether, we can receive the lowest percentage rate for money that we borrow. Okay, could affect our bond rating. All right. So that will put us in a little trouble. And so there's some things that can occur that will affect the taxpayers. All right, and so let's keep that in mind. Uh, that we will be effective if we lose this lawsuit. Okay. But that's the breaking news that I wanted to bring to you all. I think they're going to have a meeting tomorrow at the administration building. I imagine that's where it'll be. But I don't know the time. I'm just thinking that it just may be the regular time, 6 o'clock p.m. I don't know if that's a special meeting or the regular meeting. You know, I don't go to the school board meetings like I used to. So I'm just saying it's going to be a special meeting. So if you want to attend that meeting, hopefully you'll get around there and sit and listen. Okay? So that's pretty much all I have for you all on the late breaking news. Again, for those of you who just tuning in, again, there has been a federal lawsuit filed against the Blytheviile School District by Assistant Superintendent Malcolm Jones and Athletic Director Leon Harris. Both of those gentlemen's contract was non-renewed. The reason that they're bringing this lawsuit is because they allege that they pushed it back against a board member, Mr. Hammett. They're saying that because of that pushback, there was retaliation against them that put them in the position that they're in now where they lost their jobs. Okay? So they're bringing this federal lawsuit and hopefully to be compensated for what they what they has lost. And also they asking for punitive damages. For those of you who don't understand punitive damages is where the defendants will be punished. In other words, they knew what they was doing wrong, but they did it anyway. So for that, the court will award the plaintiff punitive damages, not just compensate them for what they, you know, is out of in terms of, you know, their weekly checks or whatever, however much that adds up to. But the court will also award them punitive damages, meaning the board members actually knew that what they was doing was wrong to take these two gentlemen's job and not give them due process. Okay? Didn't even want to hear them. Just voted to non-renew their contracts, along with some other things, you know, that had went on according to the defendants, as it relates to the renting out of school property and school monies that was raised. The school district didn't benefit from those dollars. Okay, in fact, the plaintiff also stated that because of the buildings being rented out against policy, that it also created a liability. Someone could have been injured or hurt. If that was the case, then that liability falls on the Blytheviile School District, which is you and I, the taxpayers, who will have to foot that bill. That's all I have, ladies and gentlemen. I want to thank you all for staying up late with me. And this was a special broadcast. I don't know when I'll be coming back on. So just stay on the outlook for me, okay? So with that being said, I want to go ahead and conclude this broadcast and say peace and love. God bless and good night. And I want to say, please jump over and do subscribe to my YouTube channel where you will get all of my notifications when I go live. And hit that bell now. Do subscribe.